Hello everyone, welcome to Court with Krissy. Maybe it's me, but having to go to the hospital and get casts put on both of your hands, yeah, you're guilty of an assault. Things go south for this defendant once the judge asks him if he's sleeping. He's not, and he can't keep his mouth shut. There are a lot of charges to get through, but believe me, stick around until the very, very end. I hope you like it. Court with Krissy is now in session.
On the record in the matter of the state of Michigan versus Dean Davis, 25-02389FY. Counsel appearance.
Good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Assistant Public Defender Joseph Hardy on behalf of Mr. Davis.
This is Dean Davis Jr., is that correct?
Yes.
Okay, Mr. Davis, I do have a felony complaint here that you need to be arraigned on. The allegations are that on or about August 5th, 2025, at the area that you did allegedly in count one, commit the act of unlawful imprisonment. The allegations are that you did knowingly restrain by means of a weapon or dangerous instrument and or knowingly restrain to facilitate the commission of assault with intent to do great bodily harm, interfering with a crime report, committing a crime, threatening to kill or injure, or interfering with electronic communications, a felony, and or secretly confined and knowingly restrained contrary to MCL 750.349B. There's a Sex Offender Registration Act notice indicating that this is a tier 1 offense under the Sex Offender Registration Act if the victim is a minor. It's a tier 2 offense if the defendant has a prior conviction for a tier 1 offense. It's a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. Count 1 is a felony. The maximum penalty is 15 years in prison and or $20,000 in fines. Count 2, assault with intent to do great bodily harm less than murder or by strangulation, alleges that on or about August 5th that you did make an assault upon the intent to do great bodily harm less than murder, and this is contrary to MCL 750.84. That's a felony. The maximum penalty is 10 years in prison or $5,000 in fines. Your DNA will be taken upon arrest. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Count 3, interfering with a crime report, committing a crime, threatening to kill, injure, or cause property damage, alleges that on or about August 5th, again, that you did, through the unlawful use of physical force, prevent or attempt to prevent another person from reporting a crime committed or attempted by another person. And the violation involved committing or attempting to commit unlawful imprisonment or interfering with electronic communications or threatening to kill or injure a person, contrary to MCL 750.4838.1 and MCL 750.483A2B. That's a felony, maximum penalty, 10 years in prison and or $20,000 in fines. A consecutive sentence may be imposed for any other crime, including any violation of law arising out of the same transaction. Count 4, interfering with electronic communications, alleges that on or about August 5th, that you did willfully and maliciously prevent, obstruct, or delay by any means the sending, conveyance, or delivery of an authorized communication by or through a telephone line, and that this was contrary to MCL 750.5405A. That's a felony. Maximum penalty 2 years and or $1,000 in fines. Count 5, child abuse, 4th degree, alleges that on or about August 5th. Are you falling asleep, sir?
Not falling asleep, just confused. I don't understand how half these charges or any of these charges, I'm gonna need a lawyer for sure, because it's how did I prevent anyone from doing anything when she willfully called the cops on me? So I just don't understand any of that. She willfully left the apartment. She willfully did anything. How did I prevent anything if she just did those things? She did those things, you know what I mean? let alone child abuse. We have a child together. How did I abuse the child?
Exactly. I'm sorry, Mr. Hardy, are you representing him today?
Yes, Your Honor. I was able to get an intake done earlier today.
Oh, I'm not used to attorneys allowing their clients just to freely talk, so I'm not gonna
You
stop
asked
him.
me
If
a
he wants-
question. I'm not falling
if
asleep. That's what's going
I
on.
asked you, were you falling asleep? I didn't ask you to say anything about the facts of the case.
I'm not falling asleep. I'm just confused on how I'm being charged with things that I didn't do.
Okay. Back
Sir.
to count 5, child abuse, 4th degree, that you did knowingly or intentionally commit the following act or acts under the circumstances which posed an unreasonable risk of harm or physical injury to a child by attacking the mother holding that child. Now, this is contrary to MCL 750.136B78. That's a misdemeanor, maximum penalty 1 year or probation for up to 5 years. Count 6 is domestic violence, alleging that you did make an assault or assault and battery upon an individual with whom you have a child in common, or a resident or former resident of your household, or an individual with whom you had a dating relationship, and that this was in violation of MCL 750.812. That's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There is an habitual offender, 4th offense notice, says take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about September 20th, 2021, he was convicted of the offense of possession of cocaine in violation of 893.13.6A in the 1st District Court of Suwannee County in the state of Florida. And that on or about September 20th, 2021, he was convicted of the offense of possession of LSD in violation of 893.13 in the 1st District Court for Suwannee County in the state of Florida. And that on or about September 6, 2016, he was convicted of the offense of police officer resist in violation of 843.02 in the 4th District Court for Palm Beach County in the state of Florida, and therefore the defendant is subject to the penalties provided by MCL 769.12. The maximum penalty you're facing is life in prison if the primary offense has a penalty of 5 years or more. The primary offense in this case does have a maximum penalty of 5 years or more, so you are facing up to life in prison. Do you understand that?
Yes, that's ridiculous. If I get life, that's unbelievable.
I didn't ask for your I didn't ask for you how you felt about it. I asked if you understand the maximum penalty. Okay?
Yeah, I understand it.
I also have file number 25-01864. Let's see here. It looks like that's a domestic violence file that you have pending before Judge Buchanan with the same victim, which means, and I see here that there was a no contact order in place, that you have a final pretrial on August 11th and a jury trial on September 8th. So there's a bond violation pending on that file because you were not to be in contact directly or indirectly during the pendency of the domestic violence case. You also were not to commit any crimes or pick up any new charges. So that matter will be set for a hearing before Judge Buchanan on the bond violation, and the court will enter a not guilty plea on your behalf. You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you can stand mute. I'm gonna repeat, anything that you say on this record can be used against you. And so you have the right in this file, the new felony file, to proceed to a preliminary examination. You have the right to have that preliminary examination within 21 days of today's date, unless the court finds good cause to go beyond that 21 days or you waive the 21 days. You're currently scheduled for probable cause conference before Judge Stacia Buchanan on August 15th at 9 o'clock in the morning. You have a preliminary examination before Judge Buchanan in person at the court August 22nd, also at 10 a.m. Did you get a notice to appear?
No.
You did not get a notice to appear?
Oh, they just gave it, I guess I haven't had a chance to look at it. They gave it to me 2 seconds before I was called up here.
Okay, and where did you put it, in your pocket?
It's in my hand.
Can you see, make sure you have the correct dates on there?
Friday the 15th, Friday the 22nd.
Very good. Okay, you have the right at the time of your preliminary examination to require the prosecutor establish sufficient probable cause that a felony was committed and probable cause sufficient to charge you with the felony. You have the right to take this matter to trial and the right to maintain your innocence until proven guilty. You have the right to require the prosecutor prove each element of each of the charges being brought against you beyond a reasonable doubt. You have the right to maintain your silence at trial, and that can't be used to prove or imply that you're guilty. You have the right to question or cross-examine in court any of the witnesses called to testify against you, the right to call your own witnesses or present evidence that you believe show a defense to the charge being brought against you. Do you have any questions about those rights?
Yeah, I do not want to waive my right to a speedy trial. I do not want to waive my right to a speedy trial.
We didn't say that you waived your right to speedy trial. We know that you will not waive your right to that, sir.
I do not want to waive my right to a speedy trial under any
But that was not
circumstances.
my question. That was not my question. My question is, did you have any questions about any of the rights that I just went over?
No, ma'am.
Okay, what is your address? Is that the address of the protected party?
Yeah, I have another address as well that I can stay at besides there.
Well, obviously, because you already have a domestic violence, so you can't stay with her, and you know that.
I know
Where you
she stays
staying?
at my place. That's my apartment. She stays there. That's fine. Okay. I go to my dad's place.
Are you on probation or on parole?
No. I would just like to say being held against her will, though. I went to the hospital.
Sir. Please stop
That was the
talking.
day before. And then the day that I got arrested the next day, she just left. Like, at no point did I have her phone, stop her from doing anything. Like, to say that I held her against her will is just ridiculous. Or took her telecommunication device. It's just
Sir, will you stop
ridiculous.
this? Please stop talking.
Okay. I'm just saying there's plenty of evidence that would prove I didn't do that. She left the house multiple times before she came to the decision that she was going to call the police because I didn't want to reconcile with her.
Counsel, you can address bond.
Thank you, Your Honor. So, Mr. Davis, we do acknowledge the seriousness of the charges. What I would say is that he is someone that has lived in Michigan his entire life. He does have another separate place to stay to keep him away from the alleged victim with the address that he just gave. I would say that according to what he stated to me, is that he does not have a history of failing to appear either. So I don't think there's any danger of him attempting to flee this court's jurisdiction. I do think that these are that with these allegations that any concern for the public could be alleviated through the use of a GPS tether. So I'd be requesting a low 10% bond, Your Honor.
The prosecutor here to be heard on bond.
Yes, Your Honor. First, it appears that he's been misleading his attorney. He's absolutely been charged with failing to appear in prior domestic violence felony
Did not
cases.
tell my attorney. I told my attorney that I had
Secondly,
not appeared before.
He
I'm
has
not the one who's misleading my attorney.
Sir,
I did not mislead my attorney. My
sir,
attorney forgot what I had
Mr.
said.
Davis.
My attorney
Mr.
forgot what I had
Davis.
said.
Mr. Davis, you have
What?
one more outburst and you are remanded and we won't address your bond. Close
Okay,
your
but
mouth.
there's
Close your mouth.
inconsistencies all through here.
Remand, bond denied.
Thank you, Your Honor.
Thank you, Your Honor.